Okay, we are going to begin this webinar. Hello, everybody. My name is Daniel Timins. I'm a trust and estates and elder law attorney. Thank you for coming today to watch our, what some people have been calling the seminal moment of Anglo-American jurisprudence, my discussion of wills versus trusts. And this will be placed on the website. I have actually given versions of this discussion before, but I never claimed it in my own space. So I'm hoping to claim it in my own space. I look forward to any questions or comments people have throughout. I do have a question coming in right now from somebody. Everyone is muted, just so you know, and we'll discuss that in just a moment. But so we're talking wills and trusts today, the difference between the two and how they impact you when you would like to use them. What's a preferable time or a preferable place to use a will versus a trust? A lot of good general information. I do want to tell people before we begin that I am recording this session. I also want to bring people's attention to the Zoom bar that they have on their screen. It should be a slightly longer green followed by red bar, either at the bottom or the top of your screen. If you have questions throughout, I want you to go to the tab that says Q&A, which I will guess stands for question and answer, and type your question in there. So we get from Chauncey, oh, can you hear me? I can hear you. So there you go. I can see your questions. I'll do my best to answer them throughout. We have a long presentation today. It will be up on the website. If you miss anything, feel free to go back to it in the future. My whole idea is that I want it on the website because this way we don't have to do this webinar again and again. But you are the lucky ones. You get me in the flesh and I get you in the flesh as well. So I look forward to a wonderful presentation. Please ask questions throughout. I'll do my best to answer them. And without further ado, let us go. Wills versus trusts. Really quickly, just so that in case you didn't know, I have to say this is attorney advertising. So once you see the disclaimer, you can't unsee it. If you have questions, feel free to look at the disclaimer again once we record the program and put it on the website. So you see we have a lot of slides. I don't want you to be scared by the number of slides today, but I want you to use this as a reference. So if you have to leave, and you want to come back and view this program at some point in the future, this is the more or less table of contents as to where you can find the different topics we're going to be covering today. So you know we're in the next section when we get there. So the first part that we are talking today, the first chapter, is really the bedrock foundations of estate planning. I went to see the movie Fight Club with a few friends of mine in the late 90s. And one guy went to the bathroom and he missed the part where he finds out who Tyler Durden is. And you just couldn't explain it. You know, you just missed out on it. For those people who are coming in a few minutes late, they may miss some very crucial estate planning concepts that I want to start with. There are 6. So these are, if any point in the program you would want to learn concepts, this is it. These are the important points. Point number 1, in the estate world, we transfer assets. We do not transfer income. If I meet with clients, I look at a tax return sometimes, that's great, but we don't really transfer income. Income is something where we don't have much control over it, right? You can tell your boss, I want more money. He could say, no, you get no more money. Or you could say, how much money am I going to get in any given month? You can figure it out if you're retired. You get Social Security and you get, your pension if you're lucky. For some of us will never get pensions. And at death, you really can't transfer income to anyone other than possibly your spouse. Social Security, sometimes pensions, but generally speaking, income only goes to one person at most when you die. So there's not really any planning there, right? Last but not least, income taxes tend to be onerous and terrible, and they're complex. That's why we have a profession made specifically to deal with it called accountants. So income is not what we're talking about today. What we are talking about are assets, because you have complete control over your assets. That's the stuff you have now. A bird in the hand is worth 2 in the bush. We can trade or give our existing assets or stuff to other people. Assets include the bank account. I can write out a check to my wife or my best friend. We can also change its nature. I can change my checking account money to mutual funds, to Bitcoin, to real estate. So we can freely exchange assets. Also, the tax treatment for assets, it's much better than for income. We are talking about assets today because that is what we transfer. That is what estate planning is. Next, let's remember that wills and trusts are both contracts. People forget that even the Constitution of the United States is a contract, right? We, the people, and the United States government, we're going to contract to this. And there's been all types of tomfoolery from the government since then. Wills are contracts, as are trusts. Wills, it is a contract between the state and them appointing an executor. So the state is a contractual party to your will. A trust is a contract that does not involve the state. It is with the person who creates the trust and the current administrator to the trust, who we call the trustee. These are important contractual differences. The only time the state is involved with the trust is if there is a lawsuit against the trust. With the will, when you die, the state in which you die is a necessary party to the contract. This is the most important slide that we have today, so get comfy because I'm going to review it in about a minute. We only transfer property when we die under two legal processes. One is by the legal concept called probate, which we've heard of, but we don't always know what it entails. And the other is operation of law. We make it easy in the United States. This is it. Operation of law just means we know who gets it the moment I die. So if my wife and I own a piece of joint real estate together and she dies, I already own it. So there's no need to look at my will. Life insurance or retirement plans name beneficiaries, or if I have a bank account, I can name it as a transfer on death account. I can say, this is my account, the Daniel Timins checking account, transfer on death, Michelle Timins. We just know who gets it. So when I die, someone shows up with a death certificate and they cross their fingers that they're the named beneficiary. And then there is probate. Probate is an ancient process that looks the same in New York as it did in Old York 500 years ago, with a few exceptions. But it's only for property that transfers by your will, and it's only property that did not transfer by operation of law. So for example, if you're a married individual and you have a joint bank account and you have a retirement plan that you name your spouse as the beneficiary and maybe a small life insurance policy, and if you have a separate bank account that has some money, but if you die, you transfer on death to your spouse, guess what? You don't need to probate your estate because there's nothing else there. Your will is meaningless. So it's important to remember that trusts fall in this category on the left, operation of law, and only property that's left over that transfers by your will, because we don't know who gets it the moment we die, and we have to look at your will to figure that out, passes under probate. Point number 4, your gross estate is every asset that you own when you die. People ask me, well, if property transfers outside of my will, does it face an estate tax? And the answer is yes. If you thought the government was going to let you get away with that just because it doesn't pass by a will, you would be wrong. Your probate estate is taxable. That is property that transfers by your will. And your non-probate estate, everything that transfers by operation of law, is also part of your gross estate. It is all 100% taxable for estate and gift tax purposes. Let's say estate tax purposes for the time being. Just because it transfers outside of your will does not mean it's not taxable. And in fact, it may be more taxable under certain circumstances for income tax. Point number 5, trust, and this is another crucial point. Trust can be created in your will, or they can be separate documents. In fact, this is kind of the point that's the heart of our discussion today. When you have a will, it creates a testamentary trust when you die. It is part of your last will and testament, so surprise, surprise, we call it a testamentary trust. It's created by your will when you die. Inter vivos, which means living in Latin, because when we want to charge a few extra bucks, we put something in Latin, that's called a lawyer. Living trusts are created, surprise, surprise, during your life. They are separate documents than your will because your will doesn't create the trust until you die. That's why we call this a living trust. It's a separate document. Your will doesn't do anything till you die. Your living trust, though, is created during your life, and it's a separate document from your will, and it can be funded by you during your life. Last but not least is that funding point that I brought up. Wills and living trusts are funded at different times. When you meet with me and you finish drafting your will and you sign it, that's great. Your job is done. You're just waiting to die and letting someone else called your executor actually collect all of your assets, pay off your bills, and then distribute everything. So you're giving your executor all the hard work. A trust, you are doing it, at least a living trust, during your life. You're collecting all the assets now. You're actually changing the title of the assets to the name of your trust. And that way, when you die, your backup trustee has an easy job because everything's already collected. That's why we don't have to probate property. And point that you must remember is trusts must be funded. They have to be funded or else they don't fulfill their purpose of avoiding probate. So wills and trusts do get funded at separate times. Your will is funded when you die, when you name an executor to collect all your assets. That's when that gets funded, your will. Your trust, you fund during your lifetime. So unlike a will, when you sign your trust, there's still a little bit of work ahead of you. You know, we're probably about 50, 60% of the way done when we sign your trust. Let's go to our first player. So in the left corner is wills and the process known as probate. So we're already on chapter 2. This is everything you're ever going to need to know about wills and probate unless you're really in a bad situation, in which case contact Uncle Dan, I'll help you out. What is a last will and testament? Well, a will is an original written or typed legal document. Must be original. There are some cases when you can have a photocopy of a will if we can't find the original will. But you got to find the attorney and the witnesses and do a lost will proceeding. It's a pain in the neck. And if no one signed that will, if it's just a draft, it's nothing. So an original will still means something. It's signed by you and witnessed by disinterested people. So if my next door neighbors happen to be getting everything in my will, even though I don't really know them that well, and they happen to be the witnesses on that will, something looks a little suspicious, right? So we need to have disinterested parties be witnesses to our will. It states who receives the assets that are still in our name at our death. So I can state on my life insurance policy, this goes to my wife. Well, if my will says I'm leaving this to my mother, it goes to my wife because it never passes by the will. The life insurance policy named somebody else other than my will. So only my will deals with only the property that is transferred under probate. It names my legal representative to my estate, named my executor. It can also name my choice of guardian for any minor children I have. The court can say no to that, by the way, but you know, they tend to like to see what I have to say as to who I want to name as the guardian of my minor child. The will is submitted to the court upon your death, and they oversee the probate process. They grant probate, but the will is only probated if there's any money or guardianship issues attached to that will. So like I said, you may have a will that never transfers any property, just sits in a file cabinet for years after you die and eventually gets lost and buried and worth millions of dollars 2,000 years in the future when they find it. Now, these are the parties to a will. There are 3 parties. Now, 2 of them are contractual parties. One is just lucky to be there. One is the creating entity called the testator. That's the person, you, who creates the will. Or if your mom died, your mom. Now, this gets changed to the state in which you die in when you die because the state steps into your shoes. The fiduciary, the person who does all the work when you die, is called the executor. And that's the other contractual party. So it's you, but you're dead, so the state takes over, and then the executor. They're the one who handles all the probate process. And then on the right-hand side, we have the beneficiaries of that will who just sit back and enjoy that cool, hard cash. That's it. Now, when are wills effective? Wills and the trust that they create, like we said, testamentary trusts, are ineffective until the will is probated. The fact you're dead doesn't even mean the will is valid yet. We still need the court to get involved. Remember, the state is a necessary party. In the state of New York, by the way, we call that the surrogate's court. It's kind of like a surrogate parent. It steps into your shoes. And the court issues an actual letter that has the state seal on it, and it is called a letter testamentary. Remember, last will and testament? They make it easy. They kind of make all the words go with one another. It's sometimes called a short certificate in certain states like New Jersey. And what this does is it states that this person I named as my executor is now being acknowledged by the court. And they're saying the executor is now appointed. Now, if you create a trust in that will, again, you have to wait until the court says this will looks good. And the court will also issue letters that we call letters of trusteeship. A letter of trusteeship is just a piece of paper that has the state seal in New York. And it says, this is the person who can act as trustee of this trust created by this will. So you see the state is a necessary party to the will. Now, once a will is probated, the process is completed, usually in a few months. But remember, we may create a trust for kids, nieces and nephews, even charities that could last 4 years. So your executor may be done within a year's time or less. Your trustee could be serving for decades conceivably. And what is the probate process? Well, this could be a whole presentation in and of itself, but I'm going to try to make it as simple as possible with 3 slides that each have 8 points on them. So probate is a legal process. I think we got that clear now. It only deals with wills. It's commenced after your next of kin have agreed to have your will probated. More on that in a moment. Where a court grants the appointment of a legal representative who you have chosen, and is called your executor, who represents your estate as if the executor was you. The executor, we say, steps into your shoes. They do everything that you could have done and collects assets that you still own after your death. So unlike I said, my retirement plan names the beneficiary, I no longer own it when I die. But the car that's only in my name or the bank account in my name, that gets transferred by my will because I didn't name a beneficiary. So he, she, the executor, can pay off your creditors, potentially bring a lawsuit. Your executor can say, hey, my friend or my family member died because of medical malpractice, or they got hit by a car. I want to bring a lawsuit because they can bring legal proceedings on your behalf. And they pay any remaining estate assets to the beneficiaries that you named in your will. So that's a heck of a lot of stuff there. Let's try to break it down a little bit. How does probate progress in New York? I'm going to kind of skip through this. I'll go quick, but you see there is work to be done. Basically, when you die, someone finds your original will, hopefully it's your executor or your attorney, and they create a petition, which is telling the court, we want to have access to this person's assets, and we're asking for the court's permission. And the executor signs paperwork that says, I promise to be a good person. The executor, who we call at that point the proponent, because the will has not been admitted, has to find your next of kin. Again, just because you leave nothing to your nearest family member doesn't mean they don't find out about this. They actually do. So they either waive their right under the will and say, I'm fine getting less, more, whatever, or I don't want anything, or they say, I'm going to give you a hard time, and you have to serve them a citation that says, show up in court. Like in, Pineapple Express, you've been served. Someone actually shows up and hands them the paperwork if they're here in New York. If it's a New York will and it's someone outside of the state, there's no actual service required. It can be mailed. It's different state by state. I could get into New Jersey, Florida, Connecticut. Let's just stick with this for the moment. If there's no next of kin who complain, the surrogate's court says, no problem. We're going to name that executor. Executor, start getting your job done. At that point, the proponent, person who wanted this will to be brought to the court, is called an executor, and they receive those letters testamentary from the court. The executor, with the help of the attorney, tells the surrogate's court how much the estate is worth, because the court wants to get paid, and they get paid based on how much is being transferred. Plus, the court also just kind of wants to know how much is passing under probate. And the executor makes sure that all debts are paid, final income taxes are paid, and any remaining funds are distributed to the beneficiary. Now, what if you don't have a will? So let's say I have a life insurance policy and a joint piece of real estate and a retirement plan. But I also have a $50,000 stock account that, I inherited from my grandfather. He said, never change any of these stocks. And I left in those stocks and they haven't done anything. It's Jim's hair tonic from the 1890s. Told me keep it. And now it's worth not a lot of money. Well, that money is still in my name when I die. There's no named beneficiary. We don't know who gets it. We call somebody who dies without a will someone who applies under the laws of intestacy. So you die with a will, you are considered to die testate. Remember, testamentary. Intestacy means without a will. And the process that they go through as opposed to probate is called estate administration. Now, estate administration says you could have given something to somebody however much you wanted to, but you didn't. So any of this leftover property, we're going to leave it to the following individuals. Number one, if you die and you just have a spouse, your spouse gets 100% of the property. That passes under probate. Number two, spouse and children. If your spouse and your children survive you and you don't have a will, your spouse is entitled to $50,000 and the rest is distributed 50-50, 50% to your spouse, 50% to your kids. If you have no spouse but you have kids, they get 100% of the property. So you see, the further out you go, the more, or the closer I should say someone is to you, the fact is they're going to get the property. So if I have a favorite niece and nephew and I don't like my kids, but I don't have a will, my kids receive the property because they're in number 3. Nieces and nephews are number 5. So it's a layer of, priority. Who gets first, who gets later on. Those who are denied if you don't create a will are your life partners. You could be married for 40 years and you're married, or even 2 years. Let's say you're married 2 years. Well, all right, you're married. What if you were dating someone for 45 years? They have no rights to your estate. You had to actually name them in your will. Friends are not entitled to anything under intestacy. It's just your family. Stepchildren, if you are a stepchild, I got bad news for you. You better tell your step-parent who loves you to create a will, because if they don't, your pets are entitled to nothing unless you place that pet trust in the will. Any organization like your church or temple, business partners, or if you wanted to give a specific piece of property to a specific individual. Nope, no can do. You had to place that in the will. So intestacy says, this is who gets it. You had a chance to make a will, but you didn't. So I do the right thing, and I actually create a will, right? So I do what I'm required to do. Well, in this will, I say, I leave some money to my spouse, but I don't really like 2 of my kids, so I leave everything to my favorite daughter. Well, guess what? If I have a spouse and kids, you'll see here in number 2, I have to place those 2 children I don't like on notice. And when I say I'm dead. So my executor, my spouse, has to say to my kids, hey, guess what? Your father didn't really like you, but here's a copy of the will, so it goes in your face. So are you going to fight this will or not? And the chances are they may say yes. The bigger problem is when someone doesn't have a spouse or children or parents or siblings, and it starts getting down to nieces and nephews, or even worse, cousins. If you have no family members before this point, and you say, I'm not really close to my nieces and nephews, my will leaves everything to charity, your nieces and nephews are your next of kin. Yes, they must be placed on notice. You say, but I don't want them to get anything. I understand. That's not how the laws of probate work. To transfer property to an individual, you have to place other parties who are more closely related to you on notice that you have a will and you're cutting them out. Why am I cutting them out? Well, look what happens if I didn't have a will. Remember this? Here, I didn't have anybody alive until my siblings, and my brother and sister both dead, so it's just my nieces and nephews. Well, that's if I have no will. If I have a will, the presumption is it's invalid. So in that case, I got to send this will, or my executor does, to my nieces and nephews saying, hey, Dan gave this all to like a woman 30 years younger than him from Russia who we just met like 6 months ago. And they'll have the right to fight that will because they're my next of kin. Example, what if I have nieces and nephews, but I leave everything to my cousins? Well, my nieces and nephews can fight that. What if I leave everything to my nieces and nephews and my cousins say, well, Dan really liked us. I'm sure he wanted to give us money. They can't sue because they are cut off by my nieces and nephews. So this is the list of priorities of your next of kin by the state. And here's what that list determines. Who on that list in what order is entitled to money if there is no will? Intestacy. Who gets placed on notice? That's what we just spoke about. So if I'm leaving everything to my cousins, my nieces and nephews will find out because they're closer to me as far as next of kin goes. Who has the better right to serve as executor or administrator? I can choose who I want to name as my executor. If they're deceased, though, my next of kin gets to decide who will be my administrator, or at least they can attempt to do that. And who can legally contest the will? That's the big thing. So what does your executor exactly do? I know there's a lot of like this mystic shroud that's about us that says this is what an executor is and what an executor does. Well, very simply, your executor becomes you when you die. And this is the list of stuff they tend to do in the order that they do it. First of all, they find they may have to pay your funeral expenses out of pocket. Someone does. Then they hire help. Usually starts with me, and then we find an accountant and movers, etc. The executor drops off all the paperwork with me at the court, or at least they leave it to me to drop it off, at which point letters are issued, letters testamentary. They start collecting your probate assets. They pay your creditors and taxes. They can get your medical records. They can bring a lawsuit on your behalf. They clean out your closet, and they ultimately give any leftover money to beneficiaries. Like I said, the executor becomes you. So when I die, Michelle becomes Dan Timins because she's my executor or executrix. By the way, the term executor is gender neutral. I know sometimes people see the term executrix. It's one and the same. I had never seen a man referred to as an executrix, but so be it. So if you're a woman and you're called an executor, don't take offense. It's a gender neutral term. Well, how much is this executor going paid? Remember, you can say how much your executor is getting paid, or you can be silent in your will. And if you're silent, these are the percentages that the executor receives. It's only on property that transfers through your will. So if I have a $500,000 life insurance policy, and then I have a $500,000 house that I wish to have sold and then distribute the proceeds to my beneficiaries, the $500,000 life insurance policy, not commissionable by my executor. The $500,000 house, though, that passes under my will is. And in that case, they're entitled to 5% on the first 100,000, $5,000, 4% on the next 200,000, so that's 4,000 and 4,000, so that's 13,000, and then 3% on the next 200,000 in this case, because they say it was $500,000. So you can see it's a graduated scale. And again, you can state whatever you want in there, but your executor can say, it's not enough, I don't want to do it. Or your executor could say, I would never want to, have to get paid for helping my beloved Uncle Dan. So if I die, my executor can say, I don't want to take it. But if you leave too little for your executor, they may say, this isn't worth it. I've seen some wills that say, my executor gets paid nothing. And the person says, well, I don't want to get involved in this. This is a pain in the neck. Make sure your executor is getting paid. Speaking of getting paid, who gets paid from your estate assets first? Well, first things first, we have to pay for your burial. So if you have any money left over in your estate when you die and someone pays your burial expenses, that person's getting reimbursed. Or maybe you pre-funded your funeral. That's what I suggest everyone do. Once they hit their late 70s, consider pre-funding your burial expenses yourself. Any leftover money that you have to go, that too gets paid, or what gets paid first? The funeral home, burial costs. Number two, you knew it was going to be us, right? You knew the attorneys were going to get in there pretty high up the list. Even we don't want to have to deal with your deceased body, but we want to get paid. So we're number two. And in fact, we're entitled to get paid before the IRS is, because someone's got to administer to your estate. The good news is, if you're named as the executor, you're number three in the list of people who gets paid. You get paid before the IRS, or the mortgage for that matter, because someone's got to deal with this deceased person's estate. So congratulations, you're almost a member of the club. Number four are preferred creditors, and that means the government. If you owe IRS or if you owe Department of Social Services for Medicaid, you got to pay them first. If you have a piece of real estate that has a mortgage, got to. Next is non-preferred creditors, which is everybody else. You know, if you have a credit card bill, or if you have anything that like hospital bills, those are non-preferred creditors. They get paid after everybody else. And then finally, your beneficiaries are paid. So you see, there are a lot of people who have to get paid first. Now, the problem comes up when you have a will that's an old will and you didn't destroy it, and now you have a new will. The problem is some states require that all original wills that can be found are delivered to them. Or even worse, let's say you say, I don't want to lose this will. I'm going to give it to a court. So the court will hold on to your will. The problem is when you update that will, you don't take that will back from the court and you have a new will. Well, guess what? When you pass away, I have to disprove that old will. And when I say I mean an attorney or your executor. So you now have two original wills, one of which you wanted it to take place. And the very first line of the will says, I cancel all past wills. But the court says, well, we happen to have a past will. You have to disprove this one. It's a pain in the neck. This is what I tell people to do. When you have an old will, don't save it for posterity's sake. Destroy that thing. Just rip it up. Make sure you have your new will. But once you have that new will, get rid of that old one. You know, you can just put it in a shredder. and keep it in a safe place. What to do with wills is a little bit beyond the scope of this discussion, but I tend to tell people keep it in a safe in their home or even in a file cabinet, or give it to their choice of executor to hold on to and use when they pass away. But that old will, that's got to go. Get rid of that old will, because you're just creating more court costs for yourself. Now, people say, what happens if I move from New York to Florida? First of all, good for you. It's just one problem. You're in Florida now. More importantly is that you have a will and say, well, what happened if I die? Because Florida is God's waiting room, as we like to say. Well, your New York will is valid in Florida under the full faith and credit clause of the Constitution. And not just in Florida, but all 50 states and all territories and commonwealths of the United States. Well, you say, I've had enough of this tax regimen here in the United States. I'm finally moving to Canada for whatever reason. I don't know. Everyone says every 4 years they're going to move to Canada. They think Canada actually wants them there. I got news for you. They don't. But if you do move to Canada, I've got good news for you. Your American will is good in Canada. And in fact, your United States will is good in the vast majority of countries, because we have treaties that acknowledge wills from other countries. And we kind of say, if you show us yours, we'll show you ours. And what that means is that if you move to Greece, or you move to Australia, or you move to Hong Kong, your will is going to be valid. And in fact, I have had wills from other countries. I've had wills in Cantonese, I've had wills in Hebrew, I've had wills in Japanese, and I've had wills in several European languages that are probated here in the United States. Your will is valid in other countries, most other countries, and vice versa. You decide to move to North Korea, I don't think your will, the United States will, is going to be valid. But don't worry, you probably don't have any property that you're going to be able to distribute at that point. Which now brings us to Chapter 3, Living Trusts. We'll take a big breath. Congratulations, you made it to Chapter 3. Go, if you're still a smoker, take a smoke break maybe. But we're going to keep going without you if that's the case. Living trusts are will substitutes. They are written documents that I create with clients. Trusts do transfer property outside of probate. When you die, the court is not involved. It is an operation of law transfer. It just kind of happens. You can, however, control the assets and protect the beneficiaries using a trust. That's a big part of our discussion coming up. These trusts are created, again, during your life, but they're called living trusts, unlike testamentary trusts that are created by your will, and there is no court oversight. I want to reiterate that. Trusts have no court oversight unless there is a lawsuit brought against them. Now, why would you transfer property with the trust? Pay me a few $1,000, create a trust document, instead of just saying, I'm going to leave my life help. That's fine. I got you. Probably going to need my help in some other way in the future, but that's okay. I got you. So you just want to make it easy. And you say, I'm going to leave this property by operation of law directly to my kids or my, favorite nephew. Well, why is that not a good idea? Because these operation of law funds are transferred outright and immediately. So what happens if my beneficiary has creditor issues? Well, Visa card now has a big sum of cash they can go over. What if they have substance abuse issues or divorce issues? Well, my child or my nephew's drug dealer or his soon-to-be ex-spouse, they're going to get a whole big bunch of the money. So I may not want that. But I said, I'm just going to transfer it outright, not in a trust. What if there are marital tax issues? Same thing. I could have done that and taken care of it if I'd left the funds in trust as opposed to jointly with my spouse, but I didn't. And what if a child is a minor? Well, minors can't hold money. So that becomes a problem too. I had a 13-year-old daughter inherit $2 million under a life insurance policy. And if something seems wrong about being 13 years old and inheriting $2 million, that's all types of wrong. We had to hold a special proceeding called a financial guardianship over that young girl. Minors cannot own money. That's why you leave it to a trust instead. You protect from all of these individuals, creditors, sycophants, what have you. Now, when are living trusts effective? Unlike your will, which is only effective when you die, a living trust is, surprise, surprise, effective while you're living. And in fact, it's in existence the moment you sign it. Now, it also says typically that it's created for your benefit. So it's not going to be much for your benefit if you're dead, right? They're usually created for your benefit during your life. Not always, but often. So once you sign it, it's in effect, but you have to remember to fund it for it to be fully effective. Just having a written document isn't enough. I, Daniel Timins, need to have the Daniel Timins Revocable Trust, but I also need the bank account to be owned by the Daniel Timins Revocable Trust. My deed needs to be owned by my trust. The title of the owner on the deed is now the Daniel Timins Revocable or Living Trust. Oh, and one more thing. Some trusts can remain in existence for centuries. So in Delaware, I believe you can, or Florida, it's like 360 years. Alaska, your trust can be in existence 999 years ago. So I think, like Leif Erikson's trust he created in the United States is probably just finally becoming invalid at this point. I have a question from Andrea B saying settlor, and the answer is yes, that is the individual. Sorry, I kind of like intermix the terms. The term settlor is the creator of the trust, and I'm going to get that into that in just a moment, Andrea. I promise. Thank you for your question, though. Keep asking questions. Here are the parties to the trust. So you kind of like set me up perfectly. There are three parties to the trust. Two are contractual parties, like we spoke about with the will, and one are the ones that just sit back and enjoy life. The creating entity, the person who comes to me and says, I would like a trust, and is willing to change the title of their property to the name of their trust, I call them the settlor. Some people call them the grantor, or some call them the creator. And we have three words for it because attorneys like to sound smart. And so we put three words for basically the same individual. The settlor is the person who creates the fund with me and they settle their affairs. I'm going to refer to this entity as the settlor today. Consider that to be you if you're creating a trust with me. There is the fiduciary. Under a will, that's called the executor, the financial girl or guy. In this case, the financial girl or guy is called the trustee. Someone you quote unquote trust, the trustee. And then, just like with the will, we have our beneficiaries who sit back and enjoy the cool, hard cash. Now, if you create a trust for yourself, you might be the lifetime beneficiary, but you're not the only beneficiary because I got news for you, someday you're gonna die. Who's gonna be the beneficiary at that point? Well, the trust tells us. So let's go over each of these. Is the settlor, who we've referred to before, also known as the grantor or the creator. They create the trust with me and they fund the trust. They change the name of their deed from their name to the trust. They change their co-op shares if they're in New York City and have to deal with that horrible thing to the trust. Their brokerage accounts or bank accounts or the beneficiary on their life insurance policy is now going to be their trust. Next is the trustee. This is kind of the most important person. I know you paid me and you're the settlor and you want this to get done and, I'm helping you. So I love you. But the most important person in this equation tends to be the trustee, the financial person. Hold on, let me just take a moment. Love you. See you later. Yes, I take time out of my webinars to tell my wife I love her and I'll see her later. The trustee agrees to fulfill the terms of the trust. So you have a document you created with me. Well, the trustee and I will review the document and they'll say, I'm good with this. I can live by this. And they're going to say, I promise to do this. You can't force someone to be a trustee, but they can do it. They act as a fiduciary. They're watching out for what the trust says. So they prudently invest the money in the trust. They pay the beneficiary either directly or indirectly, if that's what you wanted. You have a child who's kind of irresponsible. You say, I don't really want them to have money in their pocket, but I want their rent to be paid. The trustee could pay the rent directly. They file income tax returns for the trust because hopefully they're making some investments in the money that's in the trust. And they defend against lawsuits, basically against the trust funds. They also have to account to the beneficiary. Northeastern states do not have silent or secret trusts. Delaware does, and a few other states that have 7 residents do. We're talking about the vast majority of people I work with. The beneficiary at some point has to know that they are a beneficiary under the trust. Now remember, if you have investment accounts, the trustee needs to have their name be known by those financial institutions because otherwise the financial institution is going to say, well, who has the ability to write checks or make investment decisions? So you're going to have to let the financial institutions that you're working with know who the trustee is. And remember that the name of a first serving trustee is often on your deed. So if you're trying to hide, I have some people who are high publicity individuals, let's say that, and they don't want the media to know where they live. Well, if they're the named trustee on their trust, even if they call it the ABC 123 Trust or the Bruce Wayne Trust, you know, if Mark Smith is trying to make sure that no one knows he lives there, but he's the named trustee, that doesn't work. You're going to have to work with someone like me to make sure that we're able to maintain the confidentiality on that deed to your real estate if you own it owned by a trust and you want to maintain your privacy. Now, the initial trustee signs the document, as does the settlor of the document. Those are the two contractual parties, the creating individual and the trustee. So the trustee has to sign the document, and it's either witnessed or notarized. I tend to say have it notarized, but most states say witnessed is good as well. If the trustee is getting too old or it's too hard and they need help, and the trust has the ability for this trustee to name some helper, we can call this person a co-trustee, and this person works with them in the future. Two documents are needed. Your choice of trustee signs a piece of paper that says, I'm naming Joe G as my co-trustee, and Joe G signs an acceptance of that assignment, because you can't force someone to do this. They have to agree. And then we send those two documents to any financial institution so that, you know, fill in the blank. TD Bank or some other place knows now that Joe G is a co-trustee and has signing authority. Now, if a trustee can't serve, they can sign a document saying they no longer wish to serve. They may require a doctor's note if they still want to serve but clearly can't. So if someone gets a stroke and they still think they can handle finances as a good trustee but they can't, a doctor's note may serve to have that person removed. So you typically want to have a backup named in the document. And then if a trustee dies, then a death certificate tends to be enough to give to the financial institutions to have that trustee removed. And then of course we have that beneficiary who just sits back and enjoys that cool hard cash, or they get paid the benefits from the trust. Beneficiary is the best, but probably not the most important person in this circumstance. Now the question comes up, can I be all three of these parties? Can I create the trust as the settlor? Can I be the trustee of the trust and administer to the trust and make investment decisions and sit back and enjoy that cool hard cash? And the answer is, yes, you can. This is the most common type of trust, the one where you're all three of these parties. We call this a revocable trust or a lifetime trust. It's created for your benefit, and you have complete control over it. You can revoke it, modify it, change it, et cetera, et cetera. What's the purpose? Why would I do this? Number one, it avoids probate. Number two, if you're incapacitated, the property can still be administered to without any problem. You have a doctor's note. Remember, you were the acting trustee. Now you get a stroke. All it takes is a doctor's note, and now you can have your backup trustee in the form of your friend, your spouse, your loved ones, your best attorney, be your trustee, and can still allow continuity of the assets. And again, the beneficiaries here, once you die, avoid having to go through probate. A revocable living trust is the most common document that I help people create. And the reason why is it becomes their alter ego. You avoid probate with this, you maintain full control over this, and you maintain privacy and continuity of assets. A revocable living trust is the document that everyone in the world, or at least in the United States, in a perfect world, has a fully funded revocable living trust. I also know in a in a perfect world, you know, I haven't just had a 4-month reunion with my favorite breakfast cereal during quarantine. I'm not the Dan you remember going into this. Now, the trust document itself, I have a question, which I'm going to answer really quickly. Is there a suggested minimum asset to set up a revocable living trust? That's a question from Adele N. Thank you, Adele. The answer is not necessarily. It's more so the need. It's not the dollar amount that's necessary to set up a trust. So here's an example. I may only have $50,000 to my name. If I want to leave that to my favorite child, and I don't want my less favorite child to know about it, if I leave those funds in trust, it's private. Yeah, it's $50,000, which is not a small amount of money, but it may not be a huge amount of money, especially if you're on this webinar. Some people on this webinar have substantially more than that. So it's not necessarily the dollar amount. It is the need that's involved. Now, if I have millions of dollars, you probably don't want to lock that up in the probate process, which takes several months. You probably only want the trustee to wait like a day or two to begin accessing that. So there doesn't need to be a dollar amount. It's really based on the need. Now, this document that you create with me, people say, when I die, what happens? Who has to come to you and how much work do you have to do? Do you have to write out an entire new document? I've got good news for you. When you pass away and you've created a trust, you've already determined what's going to happen to those funds for the next 4 generations because you asked me to create the document for you. This is what happens with a trust and how it proceeds through time. This is an important enough concept. I've spent 3 slides discussing it. You create a trust with me and you fund it. You're the settlor, maybe you're the trustee. It states, during my life, I would like the money to be used solely for me and my spouse's benefit. And then when I die, I want the funds to be used for my funeral expenses, but then I want the funds to be held aside for my favorite niece and nephew. But I don't want my niece and nephew having substance abuse issues and getting the money. So we're going to hold the money aside if they are, have that problem and they have addiction issues. And then money can be used for their healthcare and education. And if one of them passes away, the funds go to their 2 children, and same thing, et cetera, with the protections there. And then finally, there will be a date when everything is distributed. When you die, there isn't another document that's required. Everything is in here until the final penny of this trust is distributed. There is no need after you pass away to modify this document. Everything is already laid out. That's the idea. You get to control the money. So again, the present and future actions of the trust are already contained in the original document. You don't have to come back to someone like me, or you won't because you're dead, maybe in my dreams or during a seance, but you don't have to have your backup individuals come to me and sign a new document. Everything you need is in the trust. So for example, you say, I want this trust to terminate when my youngest child reaches the age of 35. It's already in the trust. So if you die and your child's 22, don't worry. We got them covered the next 13 years and potentially even longer if they pass away or they have substance abuse issues. Every contingency or most contingencies that can be imagined are already addressed in the trust. And again, this is how a trust progresses. So basically, first step, you come to me, you say, let's draft this trust. You fund the trust with my help by changing deeds, co-op shares, bank and brokerage accounts, and life insurance beneficiaries to the names of the trust. Trustee uses trust funds for you, potentially as a current beneficiary, or if you're naming somebody else as the first beneficiary, that's fine. Trustee helps them. If a trustee can't or won't serve anymore, we're able to have the flexibility for them to name a co-trustee to work with them or a successor trustee to take over after them. And then finally, when the term or the time comes when everything should be distributed, we're distributing all the assets from the trust. That's how a trust progresses. You tend to not need me to redraft anything. What you do need me for sometimes is to make sure that when one party dies, that the transfer from one generation to the next or one individual to the next is done properly. So again, this is the progression of trust regarding their temporal frames or their time frames. There's creating of the trust with me, funding of the trust. I help you with that. If it's a life insurance policy, it funds the trust when you pass away. Their initial beneficiaries, maybe you, maybe somebody else. First line of beneficiaries dies, goes to the next beneficiaries. Certain terms will take place, no money until the child's 25, and then we give it at 25, 30, and 35. And then finally, there's a final distribution, and that's all within the trust. Now, the important thing about creating and executing a trust is done primarily, and I guess this slide is more so for attorneys, but you can join in too. Please feel free. There's the initial consultation that takes place. I meet with the client. We discuss what the client wants, the objectives, etc. We review the trust together after I've drafted it. The settlor and the initial trustee signs the document. It doesn't have to be at the same time, but they both have to sign. Does not need to be witnessed. It does, and in fact, this isn't entirely right. It could be witnessed and not notarized. So this slide isn't completely correct. So, hey, I'm human too. But you do need to have mental capacity. So if you're, unconscious on a bed, I can't just have you sign the document with someone holding your hand. Now, funding the trust does require a little bit of work. there are current assets and what I consider to be future assets. Current asset is like your co-op shares or your deed, right? You want your trust to own that. If you own an LLC or a business, same thing. You probably want to assign that business interest to the trust. And then there's bank and brokerage accounts. You have to actually go to the bank or brokerage institution and say, hey, I want to change the owner from me to my trust. And then there are future assets. Life insurance, easy. When I die, that's when life insurance is really worth something, right? It's not worth a lot to me right now. It's when I die. Retirement plans, people say, well, I'm pretty sure that's an asset right now, Dan. So what do you mean a future asset? Well, if you try to transfer your retirement plan to your trust, it has to be in your name. So when you distribute it to your trust, you're actually totally withdrawing all the funds out of the IRA during your lifetime and paying income taxes. You don't want that. You say, well, what happens when I die? Your retirement plan becomes an inherited IRA and gradually gets distributed to the trust for your beneficiaries, as opposed to naming your beneficiaries directly. So again, I consider it a future asset because you're not transferring the money now. We're really waiting till you die, because while you're alive, you're going to keep the funds in the retirement plan. We had a question. My co-op claims shares cannot be placed in a trust. Is this true? And this is from Dina. If it is, how can it be circumvented? Well, I got bad news for you, and this is part of a future webinar. Your co-op does not have to allow revocable trusts. I think they're being dumb when they do that. But I think people are being dumb when they binge watch Leave It to Beaver too, and yet it's still on Netflix. So a co-op should allow people to do this, but it is not required to allow people to have co-op shares placed in a revocable trust or a Medicaid trust for that matter. So whereas I feel for you, I help people do this all the time. Not every co-op allows it. When I started in practice 12, 13 years ago, it was probably about 15%, 20% of the co-ops allowed people to place their co-op shares in a revocable trust. And this was in Westchester. Westchester was actually more progressive than the 5 boroughs were. And I still go to Westchester. I know, but I know I've been down here a little bit more. I feel bad for my Westchester clients. It's not your fault. It's all my fault. I followed love, and that's what happened. But I'm still in Westchester, just not right now because there's COVID all over the place. But back then, it was about 20% of the co-ops. Now it's about 70% the co-ops that will allow you to do this. Now, the process is a pain in the neck, and that's a future webinar. And I promise we'll be doing that webinar. It'll be a few months from now because it requires a lot of work. But just keep that in mind. Your co-op doesn't need to allow you to place your co-op shares in a revocable trust. So I hope that answers the question. Stay tuned for more. That's my hook to come back for future webinars. The initial beneficiaries, if you create a revocable trust, tends to be you and your spouse and your kids. You maintain full control. So the whole idea is you're not really getting much benefit other than the fact that it's avoiding probate and that you're getting some protection when you pass away for your beneficiaries. You're not getting any of the juicy stuff, but you tend to be the initial beneficiary, and then future beneficiaries after you pass away or whoever you name in the trust. It tends to be your spouse, and then usually kids or your next choice of beneficiaries if you don't have kids. Your revocable trusts, however, you tend not to create them so much for you. A Medicaid trust is an exception, which we'll get into a little bit, not a lot, but most of your revocable trusts tend to be for someone else's benefit other than you. It's usually a younger generation. So keep that in mind. Irrevocable trust, the initial beneficiary tends not to be you unless it's a Medicaid trust. Future beneficiaries, well, like I said, tends to be your spouse. Usually when I say descendants, that's kids or grandkids, or if you're leaving money to someone who's not in the family and you don't like your family, that would be the future beneficiary, right? So let's say here I am, my wife and I are happy, my wife dies. For those of you who don't know, I do not have children. And let's say I want my money to go to charity. Well, my next of kin, my nieces and nephews or my sister may have some problems with that. I could name that charity as my backup beneficiary in the future. But remember, future beneficiaries for irrevocable types of trusts, it's going to be family. With certain, it's going to be charities. So there's current beneficiaries and future beneficiaries. Ultimately, when everybody has reached a certain point, the leftover money is going to be distributed. When I said, my children get this at 35. Well, when my last beneficiary reaches 35, that beneficiary wants to know that the trustee wasn't messing around with the money for the last 20 years. They're entitled to a final accounting. trustee has to potentially show what's happened every single year that they've been handling that trust. It'd be a lot of work, right? So be ready. Final accounting, if you're the trustee, you got to make sure you can provide that to the beneficiary. They may say, I'm not interested, but so be it. If they say, I want to see it, you're on the hook to provide it because they got to know what you were doing. The last thing is the beneficiary, after they get this final accounting, is going to say, everything looks good, I release you. So it's kind of like in Schindler's List where, you know, I pardon you, you know. It's the beneficiary saying, I release you. So in that regard, they're saying, trustee, you did a good job. Just give me the money. Now I'm not going to hold you in trouble. So it's kind of like the beneficiary gets the last laugh, but the trustee usually hasn't done anything too wrong. Now, it's all about the tax identification number. If I create the Daniel Timins revocable trust, and then I say, when I die, I leave the money 50% to my niece, 50% to my nephew. Well, that trust is my social security number while I'm alive. It's a revocable trust. I have full control over it. But when I die, your beneficiaries will likely come to someone like me and say, okay, Dan died. We need to figure out how we're going to get this money. Well, if the funds are left in continued trust for them, remember I wrote out the terms in the document, what happens, I still have to bifurcate it 50% to my niece and 50% to my nephew. My niece's trust gets its own tax identification number. The IRS calls this an employer identification number, even though there's no employer or employee involved. It's usually your trustee will say, let's set up 2 different trusts, and I will put that employee's name in there into the IRS's website, and they will generate a tax ID number for my niece and for my nephew. It's all about the tax ID number. You don't have to come to me after you pass away and have your trustee say, draft more documents. They're just asking me for a tax ID number, for an EIN. That's what happens. So each beneficiary's trust will get its own tax ID number because investments may be different in those trusts. Distributions may happen at different times. My niece may be 30 years old, but my nephew may be 12. You never know. I have a question here, and this is from Harris. What happens when the trustee dies after you die and before the trust has been distributed? So we have this situation where maybe I die and the trustee dies almost immediately thereafter, or something else to that extent. What happens? Well, the trust does typically have the provision that says, this is the backup for my backup. When I work with people, I try to say, let's at least name 2 people after you pass away. If both of those individuals pass away and did not name a co or successor trustee, which is a good practice for attorneys, if you're dealing with people lower down on that list for trustees, you better have them name a successor relatively soon. If, however, there's no trustee serving of a trust and the trust does not name anybody to take over at that point, you have to petition the court. And it depends on the state. I'm sticking with New York for today, so you typically go to the Supreme Court, which is not the highest court in New York. It's actually the lowest court. It has supreme jurisdiction, but it's the lowest court. Go figure. New York just messes everything up. Keeps me busy. So that's what happens if there's no trustee named. You have to petition the court if there's no other person named in the document and the current serving trustee wasn't smart enough to name their own successor. Okay, so that's how tax IDs work. Extra credit. Just make extra copies of the trust. I know we're running a little bit behind, so I'm just going to say make multiple copies of this trust, all right? Because ultimately what's going to happen, someone's going to complain about something, we can't find the trust anywhere, and now we got an issue, especially if it's an irrevocable trust. If it's a revocable trust, if you're the person who created it and you're still alive, not as much of a problem. That usually doesn't happen. It's usually like the kid or grandkid who's saying, no one can find a copy of this trust, and now you're leaving me to kind of like figure out what the heck to do. Not a good position for anybody to be in. Make multiple copies of that trust. If you have grandchildren that you love and trust, give them a copy of the trust when they turn 18 or something like that. Talk to me about it. Don't just have one copy of this trust and don't have it scanned and leave it to some attorney who's a white old dude who's like 88 years old and probably going to die and doesn't even have things on his computer, all right? Have lots of copies of this. This is why I save everything in the cloud. People say, Dan, why are you saving stuff in the cloud? This is why I save in the cloud. So your grandkids don't get messed up when they can't find a copy of the trust. Someone's going to have it. It's not publicly available, but I have it saved in multiple places. Congratulations. You made it through one of the hardest part of our sections, which is what is a trust, which brings us to chapter 4. I'll just take a sip really quickly. Give me 10 seconds just to kind of reposition myself. I got another question with that. Every financial institution I deal with has to have a copy of the trust ? That's from Andrea B. The answer is no. And I promise to answer that as well as we move on. Just give me a moment and I'm going to have a sip of water. Feel free to use this as a moment to ask or put together any questions that you may have. That's the taste of freedom. Okay, chapter 4. The several differences between wills and trusts. Let's jump right in. This is what you came here for, wills versus trusts, right? Well, let's go. Here are the primary differences. When you die, a will is public. The probate process is public. You can go to your local courthouse and find out everyone who's died and left a will to be probated, what's in that will. Wills are public when you die. You can hide it while you're alive, but the process itself when you die is public. Like I said, it's contract with the state. There is court oversight, and probate tends to be slow. The executor is paid a one-time larger fee commission than a trustee, who may serve for several years. But after you sign the document, the benefit is you don't have to do anything else. You did the minimum that you're required to do. You created a will, and now you leave it to somebody else when you die to figure all this out. Sounds like a pain in the neck, right? Don't worry, you saw your executor gets paid. So it's all right. When people get paid, it's okay. That's when a testamentary trust is created, after you die. All right? We went through that already. Last will and testament creates a testamentary trust, but you have to die and the will has to be probated first. Trusts are private. They are not public. They're, court that this goes to. It's a contract between the settlor and the trustee. The state is not involved. So there's no court paperwork unless there's a lawsuit. Whereas probate is slow because we're relying upon a government agency and sometimes a few. Trusts are fast. Your body can still be warm. All I need is a client's original death certificate and the successor trustee to come to me and say, hey, let's get this done, and we can begin administering to the property almost immediately. I've had trustees who've been able to list a house 2 days after you pass away. With the will, I have to wait for the court. I had 2 clients pass away almost at the same time. To sell their house, the trustee was able to list it 2 days after the person passed away. The will needed to be probated. The court was going slow. There were some errors. It took 7 months to be able to list the house. Who do you think was in a better position as far as finances go? Which estate? The one that had the trust. Now, the problem is this. The only reason it worked is because we updated the deed to the house to be owned by the trust. If the trust was there, but the deed was still owned in the name of the person, it never made it to the trust. The trust didn't do anything. You must fund your living trust. These are the differences between an executor and a trustee. I think we've kind of gone through this already in another slide. Very simply, your executor can do everything that you could do. The trustee only cares about the money in the trust. So if you name Mickey as trustee of trust number 1 and Maud as trustee of trust number 2, Mickey has no control over Maud's trust. It's that simple. Mickey has no ability to bring a wrongful death lawsuit or get copies of your medical records or file your personal income tax return. The trustee just cares about the money in the trust. That's why we call your executor your personal representative. They step into your shoes. Trustee just cares about the trust. Frankly, doesn't care that much about you if you've passed away. I mean, they probably do emotionally, but I won't assume that. Now, the burden of proof between a will and a trust is incredibly different. When you die, remember how we said we have to put your next of kin on notice? Even if you cut them out of the will, you have to put them on notice. The burden of proof then is on your executor. Get this will validated. Anglo-American jurisprudence is based off of family lines. You actually have to be family or married. I guess a spouse is considered family, right? Closest by, but they're not blood-wise related to you in most states, maybe in some of them. But not here in New York, New Jersey, Connecticut, or Florida, maybe parts of Florida. A trust, on the other hand, the burden of proof isn't on the fiduciary. It is on the party who's trying to fight the trust. So with the will, if I have 3 kids and I'm only leaving property to 2 of them, that 3rd kid, I have to get their consent or I have to bring them to court. If it's a trust, that 3rd child has to bring me to court. Because a trust, harder part is this. Remember, a will is public. A trust is private. how's that least favorite child supposed to find out this trust even exists? Now, if they're speaking to their sibling and, the sibling says, oh, by the way, you weren't a part of this trust. What the heck happened? Well, now you got a little bit of a problem because the whole idea was to keep the secret, right? You didn't want to fight. I mean, unless you wanted the kid to know that you didn't want to give him anything, in which case, why didn't you, you can still leave it in a trust and just say, here's $10. So the idea is that the burden of proof is on the executor. It's the hard job to get the will proven for what you want to have take place. The trust makes it much easier to have what you want to have take place without a dispute. So trusts avoid disputes far more frequently, and they're private, so it's good. Now, how long is the waiting period? We kind of went over this. If you're one of my listeners in New Jersey, you're laughing when I'm saying it takes New York 3 to 4 months, because in New Jersey, it tends to take 3 or 4 days. New Jersey probate is much easier than New York probate. New York probate is much easier than Florida probate. So there you go. Wills just vary place to place, but it tends to take far longer to deal with the will. Like I said, a trust, I just need a death certificate from the person who was the last trustee, and we can begin rocking and rolling at that point. Trusts are fast. Postmortem costs. Well, remember with the will, the whole idea is I'm not going to do much work now. I'm just going to sign this document that Dan created for me, and my job is done. So when you die, probate tends to cost a decent amount of money, not just because the court is involved, which is a big reason why, but because you've never done enough probates to get good at it. It's very rare I see anyone be executor more than twice. You tend to be an executor for your spouse, if you're the surviving spouse, and for your surviving parent. So if your parents were still married, and let's say it's a standard opposite sex marriage, so mom and dad are together, dad died, mom dealt with the probate. Well, now mom dies. You probably deal with mom's probate. If you're the first spouse to die, that's the only probate that you'll ever deal with your whole life. So you just don't do wills and probates often enough, or probate, to get good at it. So you tend to do very little work up front with the will. You wait till you die. So there's more costs involved. Surprise, surprise. Trusts are easy. And I'm the type of guy who tells people what to expect with costs. Probates, simple probate, you're probably looking at $3,000 at the very lowest end for a probate. Maybe a simple probate could be as much as $8,000 or $10,000 plus filing fees. So say 3 to 10, and that's for the easiest thing. If there are contests, or there's confusions or businesses involved, it could be a heck of a lot more. Trusts usually doesn't pass $1,000. You're probably just meeting with me after your family member died. You're the backup trustee. I create one sheet of paper. I tell you what's required of you. Maybe takes 2 hours total, maybe. So maybe not even $1,000. So wills tend to be much more expensive. There are court fees involved, et cetera. Trusts are very easy because you did all the work up front. There's no work required at the back end. Again, wills are public when you die. While you're alive, they're private until you start showing everybody your will on Instagram. But you probably don't do that. But once you die and the will is probated, it's public. If there's no property transferring under your will and it doesn't need to be brought to, it becomes public. You can go to the courthouse and look at anyone who's had their will probated will. There are no wills that are not available that have been probated. They're all viewable. Trusts are only public to the creating individual, the settlor, and the current trustee, and the current beneficiary. So if I create a trust and I say I leave everything to my spouse, and after my spouse dies, I leave it to my 3 nieces and nephews. My nieces and nephews don't get to find out about it until my wife dies. Now, when she dies, like I said, most states do not have secret trust rules. So at that point, I have to put the beneficiaries on notice and give them a copy of the trust, the backups, my nieces and nephews. But it's only the current beneficiaries who have the right to view that trust. Otherwise, a trust is private. Good, good, good. We like trust for privacy as well. Now, again, a will's testamentary trust does allow creditor protection. If there's anything left to my estate, there is no creditor protection. My estate, when you say that in a beneficiary form, leaves it to your will. People think that when they name their estate, their beneficiary, they're making some erudite statement that they're so sophisticated. And in reality, when you name my estate as your beneficiary, you're screwing yourself up. Don't do it. If I tell you to do it, do it. But I've probably told 3 clients in the last 12 years to do it. Don't be in a big rush to name my estate as your beneficiary. because it loses all types of creditor protections. If, however, you leave property through testamentary trusts, your beneficiaries get creditor protections. Now, trusts do allow, by their nature, if they're living trusts, creditor protection because you left it to the trust, right? You didn't leave it to my estate. If you leave it to the trust already has these protections in it if it's a living trust. But you have to watch out for super creditors. So this money that you placed in trust for your nephew, that's great. Your nephew owes us money. We're not going to negotiate. The IRS is a super creditor. Punks. They're worse than anybody. Though child support is also something that's pretty strong in some states, especially in New Jersey. You know, if you don't pay your child support in New Jersey, they could throw you in jail. So it's hard for testamentary trusts or living trusts to protect money from super creditors. Now, the other thing is trusts avoid ancillary probate. This is about real estate. You know, real estate is special. I've lived in tons of states in my life. So if I opened a bank account in California and then I moved to St. Louis for 3 years and then I die here in New York, well, that bank account is administered here in New York, even though I opened it in California, because money is fungible. And my probate takes place in the place in which I was domiciled or owned real estate or where I died. The problem with real estate is if I own a piece of real estate in California and Missouri, also known as Missouri, and New York, real estate is special, right? I mean, I can't take a piece of real estate from California, move it here in New York. I guess it could mail a bag of dirt, but that's still not California as far as the crow flies anymore. Real estate is special. I have to do a probate proceeding for every state in which I own a piece of property, of real estate. So there's a primary state. In this case, it was New York because I was domiciled there. But I owned a piece of property in St. Louis, Missouri, and in San Diego, California. So once New York is up and rolling, now I have to do separate proceedings called ancillary probates with that same will in both St. Louis, Missouri, and San Diego, California. That's a pain in the neck. If I instead had a trust own the real estate in California and the real estate in Missouri and the real estate in New York, I don't have any probates. Let's say I never got around to doing it for the one in New York. All right, well, the trust owns the property in California and Missouri, no probates, ancillary probates in those states. What if I died in New York? Well, if I have no other New York property, and let's say the trust owns property in California and in New York, but I forgot to put the deed to the Missouri property in the trust, I have my probate potentially only in Missouri. Trusts avoid ancillary probates, which is basically paying another several attorneys to do the work that one attorney could have done. Problem is I'm not licensed in California or Missouri. So I got to find 2 more attorneys to basically do the same thing that I did here in New York for that person who has property also in California and Missouri. So trusts are good and suggested. It doesn't have to be a $2 million piece of real estate when you have real estate in other states. It avoids additional processes. Now, there are international issues related to wills and trusts that differ. Now, wills often do require a next of kin to have waivers. Remember, we said your next of kin have to agree to your probate, notarized by a U.S. notary. It can't be like a Chilean notary, unless they go to someone called an apostille. That's not an apostle like the Inquisition, no good. It's an apostille. An apostille is more or less an international, an internationally recognized notary. So you'll get your stuff notarized in Chile, or your family member will, and they'll go to an apostille. It's a pain in the neck. It takes time, it costs money, it's annoying. So that's a negative because you have to get that signature notarized and sent to the courts. Now, the other thing is that many states don't allow non-green card holders to act as a sole executor. So if I have a family member, let's say, again, I'm Chilean, but I move here to the States for a bigger and brighter and better life, and then I pass away and all my family is in Chile, and I say, I trust my sister, who's a Chilean citizen and lives in Chile, to be my executor, they're not going to let her do it because the state has no jurisdiction over a non-green card holder outside the United States. She can be one of 2 executors, but one of those executors is either going to be a U.S. citizen or has to be a green card holder here in the States. Here are some other positives and negatives, and I would have loved to have done a whole presentation on this. So this is a lot of information all in one slide. Trusts usually require notarization for successor trusteeship. So trusts have some negatives there. But trust beneficiaries, unlike under my will, don't require notarization of their signatures. There's no court involvement. So there's no notarization of court paperwork because there's no court paperwork. The other positive is that there's minimum restraints regarding non-residents acting as trustees. Remember I told you the problem with, having that Chilean individual who's a non-green card holder, or not just Chilean, being executor? Not that much of a problem with trustees. However, there's a problem because if you have a foreign person acting as trustee, it becomes a tax issue. The other issue is that most countries do not recognize foreign trusts. So if you think you're going to move your money to the Chatham Islands and get on Google Maps and see where the Chatham Islands are, there's no reason to do anything there except to hide money. I mean, there's some beaches there, but let's face it, when you hear it, you know something is wrong, right? The United States says wills, it's good. Wills are public. We like your wills. You like our wills. We'll show you ours. You show us yours. Trusts are private, remember? So we in the United States does not recognize foreign wills. When someone asks me for a foreign will, I say not interested. So just keep that in mind. And again, if you have a non-US person who's a non-green card holder act as a sole trustee, it gets bad income tax treatment. Now, there's limited international treaties that favor wills over trusts. We kind of discussed this already. Because we have treaties here in the United States that say, we'll recognize your will, Singapore, and now you'll recognize ours, and they agree. It's all good. Like I said, trusts for other countries tend not to be recognized. Just keep that in mind. And the United States doesn't recognize foreign trusts anyway, so. Doing nothing, the whole reason you created a will because you didn't want to bother funding the will, right? You said, my executor is going to deal with this later. Primary purpose of the will is that we don't know who gets the property, so we have to look at the will. You didn't name the owner of the property under anything. You just said, I'm signing my will and I'll let the executor deal with this property later. Again, with a trust though, if you do nothing, the trust is useless. But if you work with someone like me and you funded the trust, it actually gets the job done. Those are the big differences between wills and trusts. Now, both allow control from the grave. For the purposes of this part of our discussion, I'm going to interchange both living trusts and testamentary trusts. So both of these types of trusts give you control over the money, right? You create money during your life, you either place it in a living trust or you die and it goes in a testamentary trust. It provides different types of protections for your future family members. So you don't want to leave money out, give you some estate tax savings, and it gives you protection for beneficiaries who are underage, et cetera, et cetera. So trusts allow you, remember this, see, like, I don't know if you saw that, they're puppet strings over here. See, this is what I was trying to say. You have control of the puppet strings. Very good. Prior to a beneficiary's adulthood, a trust can say, I'm not going to give money to the minor. Remember that 13-year-old I spoke about who inherited $2 million from a life insurance policy? Not a good idea. The dad should have created a trust and named the beneficiary of the life insurance policy the trust, because that way the minor didn't have to have this big financial guardianship under the court. What happens instead is, in this case, the trust says, I want this money to go to the child for the health education and, support and maintenance until they're maybe 25 years old. And then they get some money at 25, some at 30, and the rest at 35. And attorneys laugh because that's like the plain vanilla stuff that we create here for clients. So it allows trusts, whether testamentary or living trusts, to protect money for beneficiaries until they can actually be responsible to receive the money. And before that time, pay for their needs. Also, like I said, there are tranches and there are different gradual distribution methods you can use. You can completely decide what you want. I want the quarter of the money to go to the beneficiary when they're 25. I want a third of the money to go when they're 30. And it's funny because it took me like 7 years to say, wait, 3/4, what's a quarter of 3/4? It's a third. There you go. So it's a quarter, a third, and the rest at 35. Or you can allow for distributions beforehand. Again, my beneficiary's health, education, maintenance, and support, et cetera, et cetera. Or you can give the trustee complete discretion. What I tend to suggest for people is they go somewhere between some allowing the trustee to just saying, all right, if you want to just be set in stone, give it the straightforward. But you usually want to give the trustee a little bit of discretion, but you don't want to give them too much work because you're going to name your sibling and then your sibling's niece or nephew is going to just bother them all day long. You can protect beneficiaries from themselves. Trusts allow for spendthrift protection. So if my child has a $50,000 credit card debt and I die, I don't want their $500,000 bequest owing $50,000 of it to the creditor. What would happen is an attorney would call up with the trustee to name that credit card MasterCard. And MasterCard will speak with us, and I'll try to talk down MasterCard from paying $50,000 to just saying, why don't you guys take $20,000? All right, fine, $25,000. And now just leave the beneficiary alone. So a spendthrift clause allows trust funds to avoid being collected by a creditor of your beneficiary. Substance abuse. If your kid is having substance abuse problems or your beneficiary, you probably don't want to leave them money, right? Makes sense. But you want them to be taken care of. So what we tend to have in wills is a substance abuse or gambling provision, if they're a gambler, that says the trustee is allowed to help pay for rehabilitation. But if the beneficiary has a dependency problem, I don't want to give that beneficiary a ton of money. Now, again, I'm not talking about the kid who goes to Reykjavik on a rocking, bachelor party for the weekend and does something that all of us will claim we never did, but maybe some of us did. This is really about dependence. So I tell parents, typically, give your kid a chance to make some mistakes, but dependence is different than use, all right? And you can maintain any type of control with the trust. So great example. I don't like the fact that my son is dating another guy. Well, you can be called, you could be called out of your time. You could be called old-fashioned. You could be called a racist. You could be called a sexist. You could be called any one of a number of things. I don't want my child to marry someone with that skull tattoo or a certain ethnicity. Sounds terrible to you? It could be. And I'm not saying I disagree with that. But what I am saying is it's your money. You could leave it to whomever you want for whatever reason you want. This becomes a thing often with people based on religion. It's not so much sexual orientation at this point. It's really become a religious thing. So be it. Again, it's your money. If that's what you want, that's what you're entitled to. The law says if you don't want to leave it to someone because they married someone outside of your faith or has different beliefs than you, it's your choice to do it. The court very rarely intercedes regarding current public policy issues. Now we have the flexibility of revocable versus inflexible, irrevocable trusts. Now I have the word yoga on there. That's just, yoga. There you go. When can I and when can't I change my trust? Well, you can change the last will and testament as long as you're alive, right? It's your will. The very first line of most wills is, I cancel all past wills. But when you die, no one can change your will. Surprise, surprise, because it's your will. You can't change it. And that same thing happens with the trust. Because it's a testamentary trust that isn't in existence until you die. When you die, that trust is locked in place. An inter vivos trust, if it is revocable, you can revoke it as long as you have the ability to understand what a trust is and revoking and not revoking it is, as long as you have mental capacity. An irrevocable trust tends to be irrevocable by you. There are cases when an irrevocable trust can be changed by other people. But again, for the sake of this purpose, as long as it's a living trust, as long as you're alive and have mental capacity, you can change it. Irrevocable trusts, not so much. Now, who can amend them? A revocable trust, you can change at any time, as long as you have mental capacity. Irrevocable trust, if you're the settlor, you usually cannot, because that's why it's called irrevocable, right? You can't revoke it. It's right in the words. It's like saying, sugar-free cake. There's not supposed to be sugar in a sugar-free cake. You can't revoke an irrevocable trust. However, a court may be able to. If you petition the court, I wouldn't rely on them to do it, but they could. You may give the trustee power to revoke or modify the trust, or all of the beneficiaries may choose to have the trust be revoked. Now, the beneficiaries all have to be of the age of majority and not disabled. This is where it always blows up. So someone says, I leave my money as, a general pot of money to be given in my trustee's discretion, my kids and my grandkids. And you have 5 kids and they're all in their 40s and 50s and they're fine. And they have grandkids and there are a few in their teens, but there are a few that are like 8 years old. And now you can't change the trust because that 8-year-old can't make a decision. So the beneficiaries as a party to change an irrevocable trust doesn't always work out very well. You may have to wait a very long time. Now, again, the benefits of a revocable trust is that it avoids probate. It allows continuity of management. You know, it gets the same income tax treatment as you. So when you have a revocable trust that you can change and you're all three of those parties, it doesn't get any different income tax treatment than you. In fact, we don't need a separate tax ID number. It just goes on your tax return typically. And you can change it at any time as long as you have mental capacity. These, again, are the parties to a revocable trust. The person who creates the trust, the settlor, is you. The trustee, you. As long as you're able to, meaning you don't have a stroke or you're incapacitated, or you choose to name somebody else and you step down. Doesn't happen too often, that last one. And the beneficiary, it's you until you die, and then it's someone else. I got bad news for you. You're going to die one day. I'm the first guy telling you this. I got bad news for you. There's a lot more things in the world you haven't heard then. Now, irrevocable trusts have three distinct benefits, and it tends to only be one of these at a time. When you create an irrevocable trust, you're only doing it for three reasons. My pride and joy of 3 years ago was getting picked up by NASDAQ on this specific article I created. There are only three reasons to have an irrevocable trust. Number one, to save money on estate taxes. Number two, for creditor protection for you, unlike your beneficiaries, you already get creditor protection. Or number three, to qualify for government needs-based programs, which is typically Medicaid. These are the only three reasons you should create an irrevocable trust during your life. This is it. Estate tax savings, creditor protection for you, or maintain government benefits like Medicaid. I do number three all the time. I do number one with some regularity. Number two, when people hear what's required, they don't want to do it so much. Now, the problem is if you give yourself too much control over these irrevocable trusts, you may be stuck with an irrevocable trust that you can't do anything with, but you don't actually qualify for any of these three benefits. So don't try to ever draft one of these trusts on your own. And in fact, don't ever try to draft any one of these trusts with someone, 2 years out of law school. Just don't do it, man. Don't do it. And here tend to be the parties. The big thing is that you create the trust as the settlor. The trustee is typically not you, and if it is you, it's definitely not the beneficiary. And if it's the beneficiary, it's definitely not the trustee. So you'll see there's like this big line. If you can see my cursor, and I think you can, there's a big line in between these two people. The one who controls the money and the one who gets the money, right? That's a big deal. Plus, it's irrevocable. And when you do this, the IRS or the government or even creditors in courts say, you've divested yourself of enough control that we're going to give you one of those three benefits: estate tax savings, government benefits, or creditor protection. Now, estate tax savings, you save money on estate taxes. This is kind of its own discussion. I love to talk about it more. If you want to look at this a little bit more, you're going to go back to this presentation. You're just going to hit freeze on this slide. But, you could save money on estate taxes. It's just not a big deal because most people can pass $11.58 million without a federal estate tax. New Jersey has no estate tax. New York has an estate tax after $5.83 million, and Connecticut's pretty high too. Florida has no estate tax. So I deal with these estate tax saving trusts for plenty of clients. I'd say 90% on this, people on this webinar probably doesn't apply to. Asset protection trust, this is protecting you from your creditors, not your kids from their creditors. This is a big deal. Hey, this sounds great, Dan. I want to protect my assets from my creditors. But do you really? Because here's what's happening. Don't forget, you may be the beneficiary, but you're not the trustee, number one. Number two, the trustee tends to have to be a trustee who is located in Nevada or Delaware or Alaska or North Dakota, basically one of these states that has 7 people in it. And these are one of them, and they can say no. And plus, you're paying that person who's acting as a trustee. You cannot be typically the sole trustee of these asset protection trusts. You got to pay someone to act as a disinterested trustee. Now, if you're an OBGYN and you're going to get sued sometime between now and the end of this webinar, I would understand having one of these trusts. Or if you're a general contractor or an architect and you're probably going to get sued sometime before tea time today, maybe you want an asset protection trust. But most people, when they hear what's required, hiring a third party who can say no to them whenever they want, they got to get the trust created by someone outside the state. There's a minimum fee that this trustee is going to pay and a separate tax return that has to be filed. They're going to say, nope, stop, and not interested. But it happens every once in a while. This is the big one for irrevocable trusts. Everyone who comes to me and says, Mom worked hard, she has a $300,000 house in Long Island, and she has $200,000 in the bank, and she gets a pension, and that's all she's got. And I want to make sure I protect that money for me. And I say, well, first of all, is your mom at mental capacity? If they say yes, I say, okay, let's talk to mom. She's going to create an irrevocable trust to protect that money so that she can qualify for Medicaid. And I have plenty on my website, and I've done webinars already a bit on Medicaid, and I will be doing more because the rules are about to change. So long story short, if you have questions about Medicaid, now's the time to ask. Starting October 1st, it's going to become real different. But this is the type of irrevocable trust that I create for people who have too much money to qualify for Medicaid. So again, lots of trusts that can be discussed here. This will be a separate webinar in the future. If you have questions about Medicaid, don't wait for the webinar. Contact me now. Now, income tax treatment, pretty straightforward. Trusts only get taxed once. If it's a revocable trust, I maintain full control over it, so I get taxed. And I actually pay the best income tax, not Dan personally, but I as an individual pay the best tax rate. So in a revocable trust, the income taxes, it just goes on my personal income tax return. Irrevocable trusts only get taxed once. It either gets taxed if it distributes the money to the beneficiary or if it holds on to the money and does not. So let's say an irrevocable trust earns $100,000 of income in a year. It can either distribute that $100,000 to the beneficiary, in which case the beneficiary is paying the taxes at his or her preferable rate, or the irrevocable trust holds on to it. And the IRS has said, you know what, rich people, we're onto your sneaky irrevocable trust scheme. We're going to tax you at a higher income tax rate at a lower dollar amount. So that $100,000 that you had distributed to the trust's beneficiary, they're paying income taxes at the 20% tax rate. There's no 20% tax rate, but I'm just giving you an example. The irrevocable trust starts paying at the 37% maximum federal income tax rate once it's made $12,500. So it is paying 37% taxes on $87,500. Anything over $12,500. See, I had to do math there, and it got a little bit tricky, but I'm glad you stuck with me. I'm pretty sure my math is right. I think my dollar amount is wrong, though. I think it's up to $13,000. Here's the answer. Any money that's held and stays in an irrevocable trust that isn't distributed to a beneficiary pays a higher income tax rate. So it's important to realize the differences there. Funding your trust. Funding your trust, you got to do it. If you don't fund your trust, there's nothing in the trust. Now, funding testamentary trusts are easy. Well, kind of. Remember, we're not really changing anything now. Things like beneficiary forms need to be changed. It's only future assets. Like my bank account, I could leave that to my testamentary trust by naming a transfer on death beneficiary, but I'll tend to just leave it in my estate. Because if it's going to a testamentary trust, I have to probate it anyway. So it tends to only be that idea of future assets like life insurance or retirement plans. Now, the verbiage on this is terrible on the forms. So I work with Giselle, and because and she fills this in. Basically, when you leave a life insurance policy to a testamentary trust, you work with me, we finish the documents, et cetera, and Giselle has filled in there. This is the beneficiary. Ready? The trust created, or the trust for my children created by Article 6 of my will, dated July 1st, 2020. So blah, 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 blah. It sounds completely wrong, and it's a lot of words, and you can mess it up pretty easily. But the idea is that you're saying, I don't want to make it easy and leave it to a trust, that's created like a living trust. I want to make it a harder trust that's created under my will. The downside is if you ever have to change your will, now you have to update all your beneficiary forms. So this creates all different types of problems and legal billing for Dan, which is great. You fund testamentary trusts when you die because they're not around till you die, but you have to name the beneficiary correctly, and that you usually have to work with us for. Living trusts, again, can own assets in the present or the future. It's not just like the life insurance or retirement plan. You actually have to change the owner. So typically, if you've done a revocable trust or an irrevocable trust with me while you're still alive, we've done the deed change, or we've updated the beneficiary forms, or I told you we got to get with your brokerage institution and bank and make sure you update the owner on the accounts. So living trusts must be funded. I think I really beat that to heck. If you don't get that at this point, I won't say you're hopeless, but you probably need some time with me. We'll do some extra homeschooling together. Now, I had the question here before, what is the financial institution entitled to? Well, technically, the financial institution isn't entitled to your entire trust. It's entitled to the title page and the signature page. Now, sometimes they will require something called a certificate of trust, which is just a truncated version of the trust. It's like a 2-page version. It says, this is the name of the trust. This is the tax ID, maybe my social security number. Here's the list of the trustees. And oh, by the way, we hold you harmless. Now that you don't have the whole trust, just accept the certificate of trust. I can create that. Some financial institutions have their own paperwork, but basically that way you avoid showing the whole trust. I don't like it when financial institutions insist on seeing the entire trust. Why? When you create a trust with me, we have attorney-client privilege, right? No one can ask me for a copy of that unless they're a required beneficiary. So the kid that you cut out of your trust, well, he can ask me for it and I could say, go fly a kite. But when you've given that same trust document to your financial institution, there's a problem because he can send a subpoena there. And now his attorney has access to the trust that you tried so hard to keep private. So when I get financial planners who I love you guys. You know I love you guys. I gave my webinars to you for the last several months. When financial planners ask me for entire copies of the trust, I'm kind of stuck saying, like, don't do it, man. Like, you know, you could get that. It can mess up your client. So again, the financial institution's going to ask for it, and I'm going to fight and say, don't do it. I have a question here from Harris. Doesn't a POD, payable on death, and TOD, transfer on death and life insurance, avoid probate? The answer is yes, but if I die and I leave it to a testamentary trust, because I don't want to leave that life insurance to my 13-year-old, I want to leave it to the trust created in my will, my testamentary trust, I'm intentionally sending it through probate. I know it doesn't make a lot of sense, right? But you got to talk to me offline about that. That's the whole reason why we're leaving it to testamentary trusts. We wanted to go to probate because that's kind of an evil, but the alternative is leaving it to a 13-year-old and hiring a bunch of attorneys to deal with a far worse problem, which is leaving $2 million to a 13-year-old. So yes, life insurance does avoid probate. In this case, we're intentionally sending it through probate to the testamentary trust. Great question. All right, let's continue. We talked about funding trusts with current assets. Current assets are things like your brokerage or bank account, deeds or co-op shares. If you're an owner of a business, I help people move their LLC interest into a revocable trust. If you own S corporation stock of your family business, kind of a pain in the neck to have a revocable trust own that. It's real annoying. Just be ready. It's a pain in the neck. Now, someone must transfer current assets to the trust ownership or else the job is not done. I just want it to be clear. Assets that you own, like the brokerage account in your name, if it isn't owned after your trust doesn't own it. The sole exception is when you have a will called a pour-over will that says, any money I forget to name in my trust, we'll probate it and then we'll pour it over into my trust. That's why it's called a pour-over will. So it sounds good. It made it into the trust, right? Well, yeah, but you're wrong because you had to transfer the property through your will, through a pour-over will. So it's still to go through probate. So pour-over wills are not the answer for everything. Again, future assets, I kind of discussed this before. Just because we're a little late on time, I'm going to pass it. Just remember, you have to work on the beneficiary form for life insurance. If you're trying to save money on estate taxes, you actually need to change the owner of the life insurance policy. I've spoken a good deal on irrevocable life insurance trusts. Here it's called ILITs in the past, part of another program. But remember, some life insurance can avoid estate inclusion. but the owner of the policy must be the trust, and it's got to be an irrevocable trust. Remember those estate tax savings trusts? If you just have a smaller policy and you don't have a taxable estate, you know, at most you're going to have a few $1,000,000. Lucky you. You can just name your revocable trust, and it goes to your trust. Even though you don't avoid estate taxes, you probably don't owe them anyway, because you only owe estate taxes when you have several millions of dollars. Again, life insurance, like I said, is a future asset. We're going to avoid talking about irrevocable life insurance trusts. It's kind of its different discussion. Again, we will do the beneficiary forms for you. Clients of Dan, I am here to help. And it's actually Giselle. Thanks, Giselle. So here again is the example of what you got to name as the beneficiary for your testamentary trust on your life insurance or retirement plan. The trust for my descendants created by Article 5 of my will dated June 30th, 2020. So long and awful, but that's what's required, and that's why we do it for you. So we do you a great service, and it's really Giselle. So thanks, Giselle. You have to make sure that your trust is properly funded for your testamentary trust. The problem, like I said, is if you change your will, you have to change all your beneficiary forms because this referred to the will created June 30th, 2020, not July 15th, 2024 when you update your will. Inter vivos trusts, you see it's a little bit easier. It's just the name of the trust. The Robin Williams Revocable Lifetime Trust dated April 7th, 2018. Forms for life insurance and retirement plan policies is a lot more geared toward revocable trusts. I tend to we'll do them for clients, but if client says, I think I got this, I usually believe they do for inter vivos for living trusts. For testamentary trusts, I don't really think so. I'm not always so sure they're going to be able to do it. Let's continue. All right. When to use inter vivos trusts instead of wills. This brings us to the final few minutes of today. And I'll leave some time for questions. When do you use a living trust versus a will in a testamentary trusts? There's certain situations. I had the question about money. This is the question, Adele, where the answer is, doesn't really matter how much. It depends on the circumstances. So again, it's usually not about how much money that's involved. It's about the need. So if you have no estate contest required, you probably just want a will. Why? Well, if you have a responsible individual to act as executor, you can get off the hook from paying me an extra $2,500. Congratulations, no need for a trust, use a will. If you have lots of foreign family members, remember, they have to get their signatures on the waiver for wills signed at a U.S. embassy or consulate or in front of an apostille. What a pain in the neck. Create a trust. Doesn't need to be a lot of money. It's just a pain in the neck. Create a trust instead. Married but no kids? Will. In fact, you may not even need a will if you have no kids because your spouse inherits everything, unless you want to leave something to someone other than your spouse. And if so, don't tell her or him. Something may happen. All right. Business continuity, you're going to want to trust. Why? Because while we're waiting to deal with your estate, we have to get the court to agree to your will. This could take a long time. I have a family business right now that fortunately the kids have access to the money, but they're saying, well, how do we sell the business? You can't. Technically, you can't even hold the bank accounts because dad was the sole business owner. So again, business continuity, you want to trust. You just want the basics, a will is fine. And you want a secret distribution to Fifi, your secret lover, who's upstate in Rockland County. Well, I know Rockland County isn't really upstate, but it is. Well, you don't want to leave that in a will because then your spouse is going to find out. So you leave that in a trust. I actually wrote an article on about how to leave money to your secret lover, and it was called A Misogynist. I don't know how that makes me a misogynist. It just makes me a slimy person. Okay. Now, these are times or reasons that you wouldn't like probate, because probate tends to be slow because the government is involved. They must be involved. It's public because the government's involved. We don't like that. It's more expensive, but hey, you could have paid Dan that $2,500 up front to create a trust instead. You chose not to. That's fine. If you don't have a spouse or kids, you may say, what do I care? My nieces and nephews or my charities are lucky to get anything. So in that case, I say, you probably don't need a trust. But if you have no close family members who can't consent to the will, then I'd say you may want to trust, just because otherwise you're going to create a heck of a lot of problems for a future attorney to get paid on. A lot of people don't care. Again, the onus is on the executor to prove the will. And the onus is on the executor to collect all the estate assets. Trusts are none of these things. So again, the onus is not on your trustee to prove a trust, unlike a will. The onus is on the disputing beneficiary who isn't getting anything. And also, you've already collected the assets, so there's no need for them to be collected. When minors are involved, like I said, if you have a will that's getting probated and you leave property to your spouse, well, technically, the law says if you have no spouse, the money is if you have no will, the money is supposed to go to your spouse and your kids if you have kids. But my wife says, well, that's silly, Dan. I got to take care of the kids. Why would you want to leave anything to the kids? So when I die, if I have children, whether they're minors or not, they get placed on notice about my will. What does a 5-year-old know about a will? Nothing. So the court automatically appoints a guardian ad litem. And that legal term is a Latin term that means a guardian who's an attorney for the judge. And that attorney tends to be the judge's golf buddy or campaign contributor. And judges can say that I'm wrong and hold it against me. Hey, I got news for you. Every time I've seen this happen, the person says, oh, I know the judge and I like them. Doesn't mean they're your friend. So your minor child is going to have an attorney appointed for them, whether you left them money or not through your will. So when minors are involved and parents tend to have complex assets or even a little bit more assets that are passing under probate, I'll suggest a living trust instead of a will, because that way there's no court involvement. Remember, it's only when the will is involved is there a court, or if you leave money directly to a minor, then there's court. But if you have money owned by a trust or it's going to the trust, there's no court involvement. So if you have minors, you may want to talk to an attorney about having a living trust instead of a will. Now, if you get divorced, any life insurance you're leaving, I would suggest you probably want to live it to a living trust as opposed to a testamentary trust. For the same reason, this is what happens. When I get divorced, if I have kids, my spouse wants to know, hey, Dan, if you die and this money train stops, where the heck are the kids, our kids, even though we're getting divorced, going to get money from? And I say, well, that's a good point. I'll leave the money in trust, or at least I'll leave a life insurance policy to a trust. I might suggest a living trust as opposed to a last will and testament to a testamentary trust, just because it's faster. Like I already discussed, corporate continuity. If you have a business with business partners, or even if you don't have business partners, even more importantly, you probably want that business to continue. So if you own a bodega, someone still needs to be able to collect assets and pay off all the people who are, in companies that are giving deliveries. So you want to have business continuity, use a trust. If you have disabled and elderly individuals, continuing Medicaid compliance, I would suggest that you have a supplemental needs trust that's created outside of your will. It's fine to have one within the will. I just try to avoid having things be public when anything is going to a minor beneficiary or a disabled individual, because your will is public. It ticks off someone at some government agency and says, let's look at this a little bit more. I just like living trusts for these types of situations. And again, like we spoke about with international law, if you have family members that are overseas and they have to sign off on the document, whether they're beneficiaries or your next of kin that have to consent to your will, not a great choice. So again, it's not about the money. It's really about the reasoning behind why you're trying to avoid doing probate. And that's when you would use trusts. In summation, in a perfect world, almost everyone has a revocable living trust. But people still need to pay the additional legal fees for the trust, and they have to continue funding the trust. I will also say, in a perfect world, I did sit-ups instead of binge watching. Like I said, what did I say? Leave It to Beaver? I didn't actually watch Leave It to Beaver, but I think I watched some terrible shows. So in a perfect world, I'm in much better shape. I'm jogging every day, et cetera, et cetera. But in a perfect world, everyone has a fully funded revocable living trust just because it avoids probate. We know where everything is. If you get incapacitated, we are able to make sure there's continuity of assets. Now, we have some time for questions, so I'm going to just put my information out here for anyone who has any question on how to contact me. I'm going to answer a few questions really quickly. We already have the POD and TOD question, so that's wonderful. I think that might be all of our questions. I'm going to hold up this, closing this webinar for another 30 seconds, just so we can get any other questions that may be out there. Just as a final note for contemporary purposes, during this age of COVID-19, dealing with trust has been so much easier, both at the creation of the document and with people passing away. With the trust, remember, I don't need witnesses. I can virtually notarize your signature by just holding a conference. That's great, number one. Number two, funding the trust, not so bad. Yeah, I have to fund a will when you pass away. That's been a pain in the neck. The hardest part is when people have been passing away during this age of COVID, because the courts were effectively closed and most of them were not ready for electronic submissions. We did mail things into courts and courts were able to get the job done. But the point was that it was a pain in the neck for them. It was a pain in the neck for us. And if you were a family member who needed your deceased family member's money, you had trouble collecting it. I want to thank everybody for hanging in for what was a very long presentation. I hope you had a great time. I'm going to answer a few final questions. Is there something about having to give $500 to siblings in a trust if you're not leaving them much? You can leave siblings, you can leave anyone token amounts of money in your will or in a trust. I would suggest if you're going to have a trust, you leave it in the trust to them. If you're doing it as a niceness and they're not going to contest, that's great. But remember, part of the reason you create a trust is that if you sense there's going to be a contest, you don't want anyone knowing about it, right? That's why you create a trust. So if you're leaving a token amount of money to be nice, that's fine as long as they're not going to contest the trust or the will for that matter. But if you're leaving it so that you can try to get them from not contesting, you haven't given $500 isn't enough to stop someone from wanting to fight your estate plan, right? Especially if they can knock out that trust or will and they be entitled to $500,000. What good does $500 do me? So it's fine to leave that as if they're not going to fight. But if they're going to fight, I would leave nothing to that individual. There are other strategies we can talk about. I think that is all the questions that we have for today. So I want to thank everybody for joining us. You can always reach out and speak to me. And like I like to say, where there's a will, there's a way. And just make sure to protect your assets, not your income. In a perfect world, everyone has a revocable living trust that's fully funded. But in a perfect world, we're meeting face-to-face as opposed to through a webinar. Thank you once again. My name is Daniel Timins. It's been a joy.